Do you love to create, share, and consume stories online? Whether you write on Medium, listen on Spotify, watch on YouTube, or scroll on Instagram, X, or Facebook, you are part of the storytelling revolution that is transforming the way we communicate and express ourselves. But did you know that behind every story, there are legal and ethical issues related to the intellectual property rights of the creators and owners of the stories? Intellectual property rights are the rights that protect the original works of authors, performers, producers, and publishers from unauthorized use or exploitations by others, as we'll see in today's IP series episode. IP, 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 IP. Welcome to IP series, home to all things IP related, where I give you the stories, tips, and implications to business and creative decision concerning your intangible assets with real life case study. I am your host, Rita Chinda. Subscribe and turn on your notification so you don't miss an episode. Cheers, guys. All right. So here's an update regarding the Human of Bombay Stories PVT Limited against People of India Social Media PVT Limited. Turns out last month that the Delhi High Court held that there cannot be a monopoly over storytelling platforms, but has directed that parties should refrain from using each other's copyrighted material. Not sure how I feel about this update slash judgment, but I was expecting some sort of precedent. This is not a precedent that the court has set up, but I guess the court just wanted to save its time and everyone's time. Now, one other interesting fact about this case was the fact that it was a hybrid hearing. So physical and virtual all at the same time. And I was like, kind of took me back to the pandemic era, not a litigation practitioner, but once in a while we have to, pop in and out. But then there were instances where courts in Nigeria were sitting virtually at that time. And then when the lockdown ended, they kind of transitioned back into physical hearing. As an arbitrator as well, sometimes you get the experience of having to choose a hybrid hearing where you do virtual if it's inconvenient for everyone. You can meet up at the venue, or you do a physical hearing. It all depends on the parties. But yeah, if you don't know about this case, short story before I tell you the longer story. So turns out, I think that was in September when I came out, when I stumbled on this story about two popular social media platforms in India that did similar things. They shared stories of people from different parts of India, and Human of Bombay, who instituted the lawsuit against people of India, claimed that POI had copied his content, including his logo, tagline, and the format of his stories, and that they had infringed on their intellectual property rights. As usual, POI denies the allegation, stating that storytelling is a universal and democratic art form that cannot be restricted or owned by anyone. So when I saw the update, I think I commented on a lady's post on LinkedIn, and she was kind enough to share the link for me to go through the judgment. It was just 10 pages, you know. And now here is the story of the Human of Bombay and People of India intellectual property dispute. Now, HOB and POI are two major social media platforms that share stories of people from India. Now, HOB, which is Human of Bombay, was founded by Karishma met her in 2014, who was inspired by the Human of New York project by Brandon Stanton. Now, HOB has over 1.5 million followers on Facebook and over 1.2 followers on Instagram, where they post photos and captions of ordinary people with extraordinary stories. I think I followed them on LinkedIn when they went viral during the pandemic. Then you have people of India, which is a similar social media platform that shares stories of people from different parts of India. It was launched 5 years after the Human of Bombay. Now, the reason why I'm making emphasis on the date is one, for documentation. Two, depending on the jurisdiction that you are based in. If you're based in the first to use IP system jurisdiction, the dates are really important. If you're based in the jurisdiction that abides by first to file, the dates may not really matter. But it may matter when you're trying to claim priority in terms of, okay, I filed before this person on this day. I hope that makes sense. Yes. Carry on, Rita. Okay, so People of India was launched in 2019 by Agarwal, apologies, my Indian IP friends, who claims to be a fan of HOB and the Human of New York. So, there's now a thin line between inspiration and infringement. That invisible line that you also see when you're trying to balance IP owners' rights and consumers' rights. Now, POI has over 300,000 followers on Instagram, where it posts photos and captions of diverse people with inspiring stories. This is where the dispute then commenced. In 2023 September, Human of Bombay filed a lawsuit against People of India in the Delhi High Court, alleging that they had copied its content, including its logo, tagline, and the format of its story. Now, if you've gone through that 10 page, side by side, look at the similarities between the two social media platforms, their stories. HOB claims that POI infringed on intellectual property right by creating an imitative platform that confuses the public and damages its reputation. They accused POI of approaching the same individual featured on his website and asking them to share their story on POI. Now, the Delhi court issued a notice to POI on the 18th of September. 17th is actually my sister's birthday, that's why I was saying 17th. But moving on, 18th of September, expressing concern over the substantial similarities between two platforms. The court observed that there was a prima facie evidence of copying and imitation by People of India and asked People of India to reply within 4 weeks. So calculate 4 weeks from September 18th. Do the math. Lawyers don't know math. Moving on. So this lawsuit now sparked a huge debate on social media, with many users expressing their opinions on the issue. Some people were supporting Human of Bombay, saying POI, that's People of India, copied their content and violated their intellectual property rights. They said Human of Bombay has invested time, effort, resources to create original, authentic story, and it was unfair for People of India to unfairly exploit the goodwill and popularity that Human of Bombay had garnered in Mumbai, India. Other people were for POI, saying HOB does not have monopoly of storytelling, which is what the court ended up saying, and that POI had done nothing wrong by sharing stories of people from India. So while HOB was focused on a particular location, POI was for everybody. I belong to no one and for everyone. You get it? So they argued that HOB was also inspired by the Human of New York. IP is territorial. We get it. I'm not going to say more than that, but then the storytelling again is universal and democratic art form that cannot be restricted or owned by anyone. This controversy finally reached Brandon Stanton, who is the founder of Human of New York. And he also had something to say. He was like, he expressed his disappointment with HOB for suing another storytelling platform for something he had forgiven her for. Are you good? Hmm? Anyways, he said he had refrained from commenting on the appropriation of his work by HOB and other similar platforms around the world because he believed that they were sharing important stories and doing good work. However, he questioned the ethics and integrity of Human of Bombay for taking legal actions against people of India for doing the same thing. As usual, there's always Gbazbos on X, formerly Twitter. So the founder of HOB responded to Stanton's message on the 25th of September, stating that, so it's like, I express our gratitude to Human of New York and Stanton for initiating the storytelling movement and inspiring millions of people. He also clarified the lawsuit is not about storytelling as a concept, but about intellectual property on his post. And I said the reason with her. She said she tried to resolve the issue amicably with people of India before approaching the courts, as they believe in protecting teams' hard work. So you know how when dispute arises, it's not social media caller that's going to save you. Talk to your lawyers, the issue is cease and desist. That gives party the room to go back to the drawing board or go back to the table, negotiating table, have conversations and come to an agreement. The case was at that time pending in court, and it remains to be seen it will be resolved. But the court has said in its wisdom that nobody has monopoly over running storytelling platform, and that both parties should refrain from using each other's copyrighted work, which is good, but not good at the same time. Maybe pay X or do this or whatever. Um, this case has raised questions about the nature and concept of intellectual property in the digital age, where content creation and consumption are constantly evolving and expanding. So let's get into the whole IP rights storytelling platform thingy. Storytelling platforms are online services that allow users to create, share, and consume stories in various media formats such as text, audio, video, or images. So, example in line with our case study for today will be Human of Bombay and the people of India. You also have Medium, you have Spotify, you have Spotify for podcasters, you have YouTube, you have Instagram, you have X. All this platform allows users to express their creativity, to connect with other people, access, and also engage content. However, there are instances where storytelling platforms also face legal and ethical challenges in relation to intellectual property rights of the story they host. So I think last year there was a case that was filed against Now X on intellectual property infringement, um, stuffs like that. And as we know, intellectual property rights are the rights that allow creators or owners of intellectual property works such as copyright or trademark um, to have control over their creation. It also helps the creators or owners of this work um, by protecting them from unauthorized use or exploitation of their work by other people. So to address this issue, it's imperative for storytelling platform to have good policies and practices that balance the interests and expectations of all the stakeholders involved. Now, there's also that issue as to the concept of idea and expressed as a fixation in a particular format. Each IP has a focal point for determining the eligibility criteria. For copyright is it doesn't matter the quality of the work as long as it's original in a fixed or tangible format. And in the event of a dispute, parties will have to show and prove substantial similarities and copying, meaning that it wasn't the work was not independently created. Now, according to Isaac Ogba, in his book, he stated that a work is original if the resulting work is a product of one's independent effort in which it has not been copied. Assuming such independent efforts, authorship will be recognized in the resulting work, even if independently and unknown to the creator, a similar or even identical work created by another can be shown to have prior existence. As we know, again, copyright doesn't protect ideas as provided under Section 3 of the new Copyright Act of Nigeria, but rather that the work was expressed, thereby giving the author exclusive right to commercially exploit the expressed work for a term of duration. Um, Section 3 of the Act talks about ineligibility for copyright. These are works that will not be granted copyright protection automatically, and they include ideas, processes, procedures, formats, system, methods of operation, concept, principles, discoveries or metadata, official text of a legislative or administrative nature, as well as any official translation except their compilation, and official state symbol and insignia, including flags, coat of arms, anthem, and bank note designs. Insightful, right? Now, we also have to look and consider. Um, I just saw money in my book. Also, take a look at Section 9 read grants exclusive right to literary works such as the right to reproduce the work, to publish the work, to perform the work in public, produce, reproduce, perform or publish any translation of the work, make any audiovisual work or record in respect of the work, distribute it to the public for commercial purpose, copies of the work, nature of through the sale or other transfer of ownership, provided that the work has not been subject to distribution authorized by the owner, broadcast the work, communicate the work to the public, make the work available to the public by wire or wireless means in such a way that members of the public are able to access the work from a place and at a time independently chosen by them. Then another new provisions that I think will relate to this again is the moral right provision under section 14, which provides that the author of a work um, shall have the right to claim authorship of his work, in particular that the authorship is indicated as the eligible work, and when except when the work is incidentally or accidentally included in a broadcast. I think towards the end of my presentation, I was going to talk about exceptions, but let's just keep on the conversation. Um, yeah, then you also have the right to object and seek relief in connection with any distortion, mutilation, or any modification of or derogative action in relation to your work. And you also have a person has the right to object to a work being falsely attributed to him as the author. So this is from the Nigerian perspective, anyway, not the Indian perspective. When I read the act, I was looking forward to getting some citations or sections that were cited, but none of that was done. But just give me a second to verify what the Indian copyright law provides in terms of copyright protection for IP owners. What is the intellectual property that Humans of Bombay was relying on? Because they own a storytelling platform that shares various individual stories, which are then uploaded in the following format: audio, video, interview, write up, post, photographs. This would fall under the eligible works that copyright can be protected. I think I just went through the Indian Copyright Act, and I would say the eligible works are kind of similar to our old um, Copyright Act. So I will just be doing like a general overview. I'm talking about the IP, especially if it's copyright. Um, this is to achieve some sort of substantial research done on individual to share their story. However, the reason that this lawsuit was instituted was because people of India were said to have copied the exact expression and replicated it on their platforms as documents were tendered. So if you look at the judgment from page 4 to 9, it show you the similarity between the story telling platforms, the interviews, the photographs. Photographs enjoy copyright protection. Write-ups in form of literary work, audio, video, can classify it under audio visual works. What are the IP implications for storytelling platform in the era of user generated content, where content creation and consumption are constantly expanding and evolving? I think I'll look at this from the possible measures that storytelling platform can can explore in terms of registering their intellectual property rights with the relevant authorities and enforcing them against infringers or imitators such as people of India. Um, Obtaining licenses or permission from the creators or owners of the story they host before using or distributing them. So, for instance, um, if let's say you want to interview Semwa, you want to interview me, you need to get like a release consent for from me stating that I authorize you to share my story. There's going to be an interplay of personality right as well, especially where after giving an interview, it's not portrayed the way I am, and then you're kind of damaging my image and reputation. So issues like that. If you also look at it from the music angle, where um, platforms like Spotify need to obtain licenses from music labels and publishers to be able to stream their songs on their platform, you also need to consider providing clear and transparent terms of service. How many of you actually read that? Your terms of use, user agreement that specify the rights and obligation of the platforms and its users regarding the stories that they host. Um, for instance, Medium has a user agreement that states that that users retain ownership of their content but grants Medium a license to use it on its platform. All of those things, some things that we take for granted, need to also implement effective mechanisms for identifying, monitoring, and removing infringing or illegal content from their own platform. Under the new Copyright Act, we have what is called the takedown proceedings and also the protect technological protective measure. Just give me a sec. So the takedown proceeding can be found in section 54 all the way down to section 58. I think 61 has always talked about blocking access to online content. Section 6, we talk about identification of infringers. I'm looking for the section that talks about technological protective measures. Yeah. Then section 87 provides that IP owners or copyright owners may register their work with the Nigerian Copyright Commission. And this is because in the event of a dispute, it's easy for you to determine who owns what at the end of the day, who is the rightful owner, you know. Yeah, I think I just found technological protective measure under section 50. So it's a convention of technological protection measures. And technological protection measures means a technology device, product, or component incorporated into the work which is designed to effectively prevent or inhibit the infringement of any copyright related right, while circumvent a technological protection measure means avoiding, bypassing, removing, deactivating, decrypting, or otherwise impairing a technological protection measures which was put in place to effectively protect a work under the Copyright Act. And if this measure in the ordinary course controls access to the work protected under the prevents or restricts acts in respect of the work which are not authorized, provided blah blah blah. You just gotta read it, So I will say that if anyone who think that as a storyteller there are no provisions for you under the law, please take your time to go through the new Copyright Act. We also need to respect the fair dealing exceptions as provided under Section 20. I really wish that this case, like, I don't know if to say if the case is still ongoing based on the recent judgment that was given. However, I think it would have been good to explore the possibilities in terms of setting a precedent within that jurisdiction that other people can emulate. Now, fair dealing exceptions are exceptions under the Copyright Act, which um, does not include the right to control any of the acts as provide any of the exclusive acts that the copyright owner enjoys, such as the right um, produce, distribute, etc., etc. You can find that from section 9 to 14, depending on the type of copyrighted work. And these exceptions would only apply when you are not commercializing. So if you're using it for private use, you're creating a parody, a satire, a pastiche, a caricature, you're doing a non-commercial research or private study, you're criticizing, you're reviewing or reporting current events. Um, However, in order for the court to agree that you um this defense which you're relying on and whether the use of the work in particular is fair dealing, there are four things that the court will consider now, which is kind of similar to the US four-factor principle. They include the purpose and character of its usage. So in this instance between human of Bombay and people of Bombay, the court will look at whether the people of India's use of the similar stories, pictures, audio, video interview that Human of Bombay had on their platform and was now reproduced on People of India's platform. What's the purpose and character of the use? The nature of the work, the amount or substantiality of the portion used in relation to the work as a whole, and the effect of that use upon the potential market or value of the work. I think when I followed the story, I mean, you know how you're on Twitter and then you're trying to find like, the genesis of the whole conversation. So in the bit of having users put out their opinion, there was one person's comment that actually stood out for me where he made reference to the fact that Human of Bombay also actually have like a commercialization business model where if you want to put up ads or if you want your story to be put up there, you have to pay some money. um but yeah, so those are the exceptions under the Copyright Act Section 20. It's a whole list. You also have quotation in form of short excerpts from a work. If people of Bombay, people of India, why do I keep saying people of Bombay? Apologies, guys. If people of India maybe just cited or quoted Human of Bombay, that would fall under the exception to copyright. If it was what I'm doing, I reading or reciting in public or in a broadcast, not for commercial purpose or any reasonable extract from published literary work, people of India must acknowledge, their reproduction must have an acknowledgement of the title of the work and its author. It's kind of like when you're doing research, you're trying to cite an author, put the author's name based on how the kind of citation that you're using and all that. There's also the need to encourage and support the use of open licenses or public domain works or Creative Commons licenses that allow free and unrestricted use of protected work by any person. I think I came across an article recently that was talking about Creative Commons and AI. I mean, the world is going global. It's global already, but there are emerging technologies that keep popping up left, right, center, and then you're asking yourself, if I adopt all of these measures as a storytelling platform, can I then enjoy the intellectual property rights that I'm supposed to? Or would that make me as a consumer, make me respect the intellectual property rights of others? Will it also foster a culture of creativity, collaboration, innovation among storytellers and audience alike? Too many, too many things. So yeah. So I will also say again that the basics for storytellers or storytelling platforms, especially in relation to user generated content, is understand the basics, which is understanding what intellectual property is. IP is any creative or innovative work in form of literary works, books, songs, pictures, audios, visual appearance of products, confidential informations that must be used for commercial purpose. So I'm kind of like twisting WIPO's as a World Intellectual Property Organization's definition, but just to sum it up, it must be used for commercial purpose. When you create a work, you don't just keep it. Under the Copyright Act, you have provisions for studio works and um, anonymous work, which is also similar to the provisions in the India Copyright Act. I also came across a posthumous protection thingy under the Indian Copyright Act, which was very, very, very insightful to see. Um, but yeah, understand how IP is and how it affects you as a creator. Um, know that you have exclusive rights to reproduce, distribute, profit, use, prevent other people from using your work without your consent. So there's an express provision on, or guideline, if I may say so, on licensing and assigning of your copyright um of your copyright basically. So I'm trying to get this section just to reference you guys to it. So it's section 30 on assignment and license. um you know that there's also the provision for getting compulsory license to produce and publish translation. I don't think that will apply here, but I would say if this was under the Nigerian content, maybe the compulsory license to reproduce and publish work for certain purposes under section 32. Forgive me. Let's see what it has to say. So the act provides that after the expiration of the relevant period from the date of the compulsory um, license, you get the copies. So this will apply for literary or artistic work. The copies of such edition are not available in Nigeria. They don't be put up in sale in Nigeria for a period of 6 months by the owner of the right of reproduction or by any person authorized by him. In that behalf, in the general public, you have to make an application to the Nigerian Copyright Commission. So it's a non-exclusive license that you end up getting. So just take your time, go through that section to be properly guided on how to apply for a compulsory license. Why is intellectual property important for storytellers in this era of user generated content? One, your creativity and originality is rewarded and incentivized no matter the quality. Creators are protected from infringement, misappropriation, misuse, distortion, and plagiarism. You know, so other common method will be registering your brand name. So if you recall, during when I was giving like an in-depth story about or fact about the case, I mentioned that Human of Bombay had accused the people of India of using their tagline and logo. So trademark is acts like a source identifier for brand as long as it meets the criteria under the Nigerian Trademark Act of being capable of distinguishing and being distinctive enough to identify the source and quality of the goods or services. And by registering your trademark as a storyteller or a storytelling platform. You can prevent other people from using confusingly similar marks that may mislead consumers and users or damage your reputation. And registering your trademark gives you, the owner, the right to sue for infringement and seek remedies such as injunctions, damages, or account of profit. In an event where you do not register your trademark, the law gives you some sort of limited IP protection. So you can only sue for passing off but not infringement. Um, I think I already then what are the issues that storytelling platform may face, challenges that they may face, lack of awareness amongst users about intellectual property rights of storytelling platforms and their obligations, lack of enforcement of intellectual property right laws and regulations in different jurisdictions. This happened in India. Imagine if this was in Nigeria. I mean, before people will say we didn't have the laws, but we have a more um, updated law. And if you look at section 1, which talks about the objective of the new act, I'm trying to get to it so I can read it for you guys. Just bear with me a second. Yeah. So it says the objective of this act is to protect the right of authors to ensure just rewards and recognition for their intellectual efforts, provide appropriate limitations and exceptions to guarantee access to creative work. And I'm going to skip to the last one, which is enhance the capacity of the Nigerian Copyright Commission for effective regulations, administration, and enforcement of the provision of this act. So the body regulating you as a creator in Nigeria is the Nigerian Copyright Act. Then there's a lack of cooperation among stakeholders such as storytelling platforms, intermediaries, regulators, law enforcement agencies, or courts in addressing intellectual property right issues. Lack of balance between the interests of storytelling platforms and the interests of other parties such as users, competitors, public domain, advocates, or fair dealing proponents. So there was something while I was going through this. I think again I just realized that we were talking about the compulsory license era. There's also a compulsory license for public interest that's found under section 35. Yep, got it. Section 35. So says that the commission may authorize the use of a work by any person for the purpose of rectifying the abuse of a dominant market position or to promote public interest. Public interest wasn't defined, but then you also need to apply for this license from the commission. It's a long read anyway, so read that as well. How can how can how can storytelling platforms adopt a more proactive approach in protecting their intellectual property right and also respect the intellectual property of others? They need to educate their users about intellectual property of storytelling and their benefits, engage stakeholders to establish standards, best practices, and code of conduct. Very important. I think we've seen that with the writers' strike in the US. A lot of conversations on that. So I think that's something that storytellers and storytelling platforms should adopt as well. When I attended um, the AFRIF session, one of the sessions was on creating standards, best practices, kind of like an imitation of what the American writers of the SAG-free uh, did in the US to in order to stamp their feet in relation to emerging tech such as the use of AI to rewrite scripts and all of those things. Enforcement, we have enforcement provisions through either going to the Federal High Court or exploring alternative dispute resolution mechanisms such as mediation, arbitration, negotiation, conciliation. There's also the dispute resolution board, which the act under section 90 provides that the Nigerian Copyright Act would set up a dispute resolution board to resolve issues in relation to licensing, royalty payment, and any other thing they deem um, fit. Oh yeah. Then you also look at the evolving intellectual property rights strategies and policies to adapt to changing needs and expectations of users and the society. Mm-hmm. Um, how can this be done? They need to promote a culture of creativity by inviting and supporting storytellers and audience from different background, perspective, experience, and identity. I think again, encouraging diversity and inclusion. The human of Bombay and the people of India can collaborate to ensure diversity and inclusion, and that's also enrich the quality and variety of stories they have, as well as foster empathy and understanding amongst the users. And they can also facilitate feedback and interactions, support experimentation and exploration by promoting a culture of innovation and creativity, um, by helping storytellers also try out new formats, genres, styles, techniques, as well as challenging themselves to create original, novel, and surprising story. It can help audience discover new stories, authors, medias, provide features such as recommendation, suggestion, playlists, or a collection of, you know, support experimentation. So what do you guys think so far? Do you agree or disagree with all of these things I've been saying? Do you have other suggestion? You can send me an email to ipseries gmail ipseriesInfo@gmail.com. Oh yeah. So we're going to move into um an interesting conversation still on this. Please don't get bored listening to me, guys. I they beg. I am pleading, okay? So one other interesting conversation that I believe storytellers and storytelling platform will enjoy listening to me talk about today is monetization of digital content, which has its own challenges, especially for those who own storytelling platforms, such as websites or apps that allow users to create and share stories in various formats, such as text, audio, video, or interactive media. Now, one of the main sources of revenue for storytelling platforms is advertising. And you do this by displaying ads on the platform itself. For instance, YouTube, you want to watch a YouTube video, lots of ads. I think as well, Instagram is incorporating ads, Facebook as well. You go on someone's website and you're seeing ads. Too much. Sometimes it's annoying. But then, they have to make money. At the end of the day, you can also offer branded stories that feature sponsored content from advertisers. But then you also need to look out for the advertising guideline within your jurisdiction. So you're not going contrary to what the law provides within your territory. Another way to monetize the digital content for storytellers is by selling premium content or subscription, which we are seeing a lot of platforms like Instagram, X doing, you know. Yeah, it helps you to sell individual stories or subscription. I mean, a lot of people still use YouTube, but now it's easier for you, especially in this user generated content and short video formats on Instagrams are real easy for you to give exclusive and premium. Some of the storytelling platforms also use online courses as a form of premium content. Another way you can monetize it by leveraging the fan base of your creators. I think the NFT era showed how creatives can key into fan base. And another what's it called? Another case study would be how the K-pop industry monetized fan base. This can be done by offering merchandising, donation tips, crowdfunding, or just allow fans to support your business. You also have a shop feature that lets users buy product related to the stories they like. Some storytelling platform also integrates external services that enable fans to support, such as Patreon, Spotify for podcasters, or Spotify basically just introduced or went into a collaboration with Patreon. So these are some of the common monetization model and strategies that storytelling platform owners can use to generate revenue from their digital content. So to that user who kind of made the human of Bombay founder like an evil person for trying to monetize, have like a monetization model and strategy for our platform, I think this would answer your question in terms of all of these things. So how do you then protect your work from being copied or stolen or misused by other people? You need to register your work. Your copyright grants you automatic protection, but like the law provides now in Nigeria, you have to deposit a copy. I mean, the commission has been saying that, but now it's been stated in the law. They did not use the word shall. They say you may register. So it's at your discretion. And also looking at it from the AI generative work aspect, where the US Copyright Office refused giving the full copyright protection to the Zara of Dawn work that was created, you know, registering your work basically gives you legal rights, backings, and remedies in case of infringement. You also need to find a good IP lawyer that understands copyright, advertising, tax, labor, employment, uh, contracts, all of those things. They'll be able to guide you on the complex and international issues. Also, a dispute resolution practitioner. So it's not a core litigation practitioner, but someone that thinks like a business person. Instead of going to court, let's mediate. Um, Instead of going to institute a lawsuit, let's send a cease and desist letter, all those things. They help you draft contract, licenses agreement that protects your IP assets. They're basically your partners. Lawyers are your partners if you're creative. Know that. Use clear and visible signs or notices to mark your intellectual property, such as using the C in a circle or TM to indicate your mark is unregistered, or R in a circle to indicate your mark is registered. It's also a statement of ownership or permission. You need to also learn to monitor and enforce your IP using tools such as Google. Okay, using Google allows to track mentions of your IP on the web. You can also send cease and desist letter, file complaints to infringers, oppose registrations, all those things. Be careful with sharing and collaborating. While sharing and collaborating can be beneficial, you also need to be careful how you disclose and distribute your IP. This is where the trade secret elements will come into place. Trade secret is the only IP that um, doesn't basically require registration, but you must take um, make efforts to preserve and ensure that that information doesn't get into the wrong hands. You know, you also need to discuss how the IP will be used, who owns it, how the profit will be shared. IP provides for joint collaboration and joint authorship. You should also use secure platforms and software to store and share your IP. There's data protection elements, the cybersecurity elements. You know, now we're talking clouds. Everyone's talking about blockchain, this machine learning, etc. So these are some of the ways that you can explore protecting your um, intellectual property. So I don't know if I think yeah, I did like a very good example of fair dealing. And I was talking about general section in on that copyright. So this is a very important concept in storytelling, as it allows storytellers to reuse and remix existing material to create new and original stories, or to comment, criticize, or create a parody. So ensure that you understand all these concepts. Fair dealing is not a blanket permission or a simple rule. It's very complex. It requires careful consideration and analysis. So your lawyer, who is your bestie, your main bestie, should be the person that you should be engaging at this point. There are also other cross-border related provisions that one can consider. Um, the Open Source Initiative, which is like a non-profit organization that promotes and advocates for development and distribution of open source softwares, which can be freely accessed, modified, or shared by anyone. Um, but yeah, there are different laws and regulations that guides copyright. Um, for us here in Nigeria is the Nigerian Copyright Act of 2022. So I guess that covers it. But if you have more questions on how storytelling can boost your personal brand and business value, please hit me up. Not hit physically, Ejo. So just to conclude, I mean, we know that this digital era of user-generated content and short video formats poses a lot of challenges such as competition, as we can see in our case study for today. Everyone is vying for attention and interest of the audience. And in order for it to stand out, you need to create original works. You also need to find your voice, your style, your niche. Avoid copying or imitating other people. Trying to be honest and respect other people's events and how they portray it. Verification of facts, audience engagement, interaction, feedback, collaboration with other storytellers, influencers. Like my friend Beverly will say, collaboration is the new competition, not the other way around. Storytelling on social media platform is a dynamic and exciting field, but it also requires skills, responsibility, and passion. So, if you are a storyteller or you aspire to be one, I hope this episode has given you some sort of insight and tips on how to create engaging and original stories for social media platforms. Thank you for listening to IP series, and don't forget to subscribe and share your stories with us. Until next time, happy storytelling, guys.